Hi, friends. Welcome to Lawyers Info Hub. It's always a pleasure to create content on this platform. Thank you for always stopping by to check what is new on the channel. My returning subscribers, I thank you. Today, we're looking at when a matter is adjourned indefinitely. What happens? Lawyers Info Hub is a platform where we share legal content, we demystify legal concepts, you know, to make it easy for clarity, understanding, and for use in our daily needs, practice, and for law students. So when a matter is adjourned indefinitely, what comes to play is that there is an issue that has made the court to what adjourn. And those issues or instances could be one, where there is a ruling of that is an interlocutory ruling and a dissatisfied party has appealed. That party comes back to the court to let the court know that there is an appeal over the ruling of the court, and the party will go ahead to file a stay of proceedings by way of a motion. Some other times, I've seen instances where someone will file an affidavit of fact attaching the notice of appeal filed, evidence of transmission of the record, and notify the court that the court lacks jurisdiction to proceed with the matter as the court of appeal is seized of the facts of the matter and is seized of the matter. Some other times, we've seen routes how people go through the route of filing a motion for stay of proceedings, attaching the notice of appeal, evidence of transmission of record to let the court know that ah, you are no more seized with the facts of this case. The Court of Appeal is seized with the facts. And even if there is a counter affidavit, the court will rule on it to determine if he can continue or if he cannot continue. And if the court rules that he cannot continue with the proceedings, then the matter will be adjourned sine die. That means adjourning without a date till a further date or a further time, which may be what unknown or which is unknown because the determination of the court, the matter at the appellate court may not be known to the parties at the time the judge is adjourning. Some other instances, senior judges adjourn for report of appeal, meaning they adjourn for a long time, say 5 months or 6 months, so for parties to return to report what is going on at the court of appeal. So when a matter is adjourned without a date, we say it has been adjourned what sine die, and there are instances which I've just stated one instance for example. Now another instance is where especially in a complex matter, just like the one of Nnamdi Kalu, where we saw that the matter was adjourned indefinitely without a date because of issue of the judge who has recused herself and the matter was reassigned to her again and all the back and forth. So there are some complex cases or cases of national importance or for one reason or the other, someone who raises an objection or a report of bias on the part of the judge. So a party can say, my judge is biased against me, citing instances and does the petition to the chief judge who reviews it. And if he feels that there is no more confidence on the judex, what the chief judge does is to reassign that matter to another court. And so when a judge is aware that there's a petition and there is request and the chief judge has looked at the issue and has requested that the matter be taken to the admin judge for further reassignment. In that instance, the judge no longer adjourns the matter to a day. The judge just adjourns sine die, pending when the administrative issue of a reassignment is done. It's now left for the new judge to give a date. So in such instance, a judge can adjourn indefinitely. Another instance is, for example, where in the course of handling a matter, a judge, maybe adjourned, and before the next adjourned date, the judge is elevated to the court of appeal or an appellate court or further court, or the judge passes on. In that instance, there will not be a further date. What happens is that there will not be a date for the matter till the chief judge or whoever is in charge, does the administrative work of reassigning the matter to another court. So for that period, it could take 1 month, it could take 2 months, 3 months, 5 months, 6 months. There will not be a date for the matter. The matter will have to move to the admin judge who reassigns the files. It's now when the files are reassigned to a new judge that that matter gets a date. Now, there's also an instance where, for example, a matter the court have ruled that the matter be transferred, where a party by way of emotion has applied that this matter be transferred to another division for the basis of reasons of the parties, the transaction happened there, defendants are in that location or whatever reason, and the court feels or holds the view that this is right for me to transfer this matter to another division. In that instance, the court can no longer give a date. Once the court have ruled and stated, yes, I agree, or the application of the appellant or the respondent succeeds, the court can no longer give a date because it can no longer take the matter. So in that instance, the matter is adjourned indefinitely, pending that administrative work of transfer is completed, move to the jurisdiction that the court has ordered, a new date is given, then the file can get a date. So these are instances where you can say a matter has been adjourned indefinitely, or what we call sine die. So when you hear that the matter is adjourned sine die, it means that the matter has been adjourned till a future date which is unknown. That's a literal way of explaining it. Because I've seen instances where people go on appeal on an interlocutory, at the interlocutory stage, stay 5 years, 10 years before coming back to continue with the matter. So it is when the parties have come back from wherever they are going at the appeal, at the appellative stage, that the matter can now continue. So for that long time, there will not be a date. The matter is adjourned what indefinitely. So when you hear that the matter has been adjourned sine die, these are the instances that should come to your mind to say, okay, this may be the reason why the matter has been adjourned sine die. Why the matter will be adjourned sine die is that the lower court does not want to interfere with the judgment of the Court of Appeal or what will happen at the Court of Appeal. Because if the lower court is going on with the matter and the Court of Appeal is also going on with the matter, the judgment of the lower court will make mockery of what the Court of Appeal is doing or vice versa. So it's important that one part stays proceedings and the other part proceeds so that there will not be confusion. So that there will not be confusion. So when a matter is adjourned sine die, the instances I've listed earlier are possible instances that could make the court to adjourn sine die. Some other time, we have seen instances where people did not even file stay of proceedings, affidavit of fact, just by oral, argument to let the court know what has happened, and which the other parties in the court are also privy to. So in that instance, we have seen instances where, without an application, the court, adjourn the matter sine die, all because all parties have confirmed that the matter is at the Court of Appeal or at the Supreme Court, and any step they take will affect that other matter. Another instance is also when the court can adjourn indefinitely is when a matter is for consolidation. When the chief judge of a state has ordered for the consolidation of a matter. On issue of consolidation, when a party would have written to the chief judge who received the application and confirmed that the matter will be consolidated, having looked at the similar circumstance. At that instance, the judge in whom one of the files is present, which is the older file, which is the file that came earlier, will release that file to the administrative judge without a date. That means he will adjourn without giving a date. And the file will be taken to the administrative judge for reassignment, which is an administrative process. So at that point, when a court is aware that there is an application for consolidation, the court does not give a further date. The court will just release the file as directed by the chief judge to the admin judge, who looks at where is the place that this file, the two files or three files should go. Normally, they always refer that file to the place where the earliest of those suits were filed, so that that judge will take up all the cases. So in that instance, where a matter can be adjourned indefinitely, it is when the administrative judge sorted out the issues of the where the files will be tried, that a date can be given by that court. So in these circumstances, there may be also other instances I may not remember now, but majorly these are the instances where a court can adjourn indefinitely, or what we call sine die. And when such instance comes to play, parties, goes to sort out that appellate matter, or the Supreme Court. It's when they sort it out, they cannot think of coming back. So, friends, if you have a question to ask, you can drop it under the comment section. We'll revert to you. If you're yet to subscribe, please hit the subscribe button, share it, to join this wonderful family. And I know and I do hope that you enjoy your stay. We have over 200 videos on the channel. Go and check them out. Go and check them out and go and check them out. You see that you will love every bit of it, and what you hear from there can help you in your career, in your work, in your even in your practice as a young lawyer, in your life as a law student. Do take care and know that you can always be the best, and the top is meant for the best. So strive to be the best so that this cloud can be your stepping stone. Do take care.